Well, welcome back to the Cordell and Cordell Virtual Town Hall. I'm Scott Trout, Managing Partner and CEO of Cordell and Cordell. And I'm glad you joined us today. We're going to talk about the Divorce School for Men, which is going to break down some of the more common questions guys have and some of the things that they go through when either facing divorce, in the middle of a divorce, or even post-divorce. We'll try to answer your questions today. Before we introduce our panel of Cordell and Cordell attorneys, just a few things to get out of the way. Of course, you can always submit your questions. We're going to get to those in the second half of our virtual town hall. If you want to submit those in the Q&A section today, we'll be getting to those in the second half and try to toss those to the panel of Cordell and Cordell attorneys. Just use your first name and a state so that if we have an attorney in your state, we'll try to send them your way so that we can try to get the appropriate law and question answered. Now, along those lines, keep in mind that today we cannot give you legal advice. This is informational, educational. The only way to do that is to have a consultation with an attorney that practices exclusively in family law like we do here at Cordell and Cordell. If you haven't subscribed to our podcast, we do it twice each week for about 10 to 15 minutes. You can go to iTunes and you can subscribe. You'll be alerted every time a podcast is dropped, and you'll be up to date. Find a topic that relates to you and of interest, and we address some of your questions during those podcasts as well. Check us out on social media, as well as our YouTube channel. We've been doing this virtual town hall since March, around the beginning of the pandemic, and it's loaded with information as well as all of our podcasts as well. So if you want to schedule a consultation, you can reach out to us by going to the web at cordellcordell.com, or you can give us a call for any of our nationwide offices, including the United Kingdom, at 866 Dad's Law, 866 Dad's Law. We can do that consult in person, on the phone, or via video just like this as well, whatever's more comfortable for and convenient for you. So let's get to our panelists. Again, submit your questions in the Q&A section. We've got some. We'll get to those in the second half. Let's go to our panel. Right now, John from Knoxville, welcome.
Good afternoon, Scott. Nice to be here.
Thanks for joining. Brad, Tulsa, Oklahoma.
Hello, everybody.
And we have Jamie up in Colorado Springs, Colorado.
Hi, thanks for having me.
And rounding out the panel of Cordell attorneys is Jessica out in Peoria, Arizona.
Thank you, Scott.
There you are.
I think we're ready now.
Great. Sounds good. Well, welcome everyone again. We have some questions being submitted as we are already underway, and we'll get those to the second half. So keep submitting those. Until then, let's take a real quick commercial break, and we'll get started right away after this.
For many men, divorce brings a bewildering sense of loss. After years of commitment and responsibility, you find yourself alone, like you're the only person in the world. But you don't have to walk through this alone. We can help. For more than 30 years, Cordell & Cordell has guided men through the challenges of divorce. You're not alone. Call Cordell & Cordell, a partner men can count on.
All right, welcome back. Let's get to divorce school. There are so many intricacies, and we talk about in the podcast, we try to break down the legal words and make it a little bit simpler to understand. And actually, the intent here is to create more questions for you so that you can take those to your attorney. And keep in mind, you want to find one that practices exclusively in family law, like we do. There are plenty of them out there. I encourage you to find one. And if you don't, again, you can call us at 866 Dad's Law or cordellcordell.com to schedule a consultation. Be the best 1 hour of your time to get more information. So let's start up. Brad, one of the things I think is more confusing when we talk about divorce and understanding it, and why we're trying to, divorce school, divorce 101, is guys have a lot of questions. They're usually, that bomb is dropped on them that someone's just filed for divorce, and they may have kids. And the biggest question is kind of twofold. One is, what role am I going to have, now that things are going to change? And what do all these terms mean when we talk about physical and legal custody? Because there's a lot of misinformation out there. So maybe let's break it down into those definitions first. What is the difference between legal and physical custody? Maybe you can help define those.
Absolutely. That is a great question, Scott. And that is one I get from clients all the time. What is the difference between legal and physical custody? Well, legal custody essentially is who is going to make the decisions for your children or child, the decision-making parent in the household. And there's two different kinds which is where it kind of gets confusing. There is joint legal custody, and then there's sole legal custody. So joint legal custody means that both parents are going to be making decisions on the best interest of the minor child or children, meaning both parents have to communicate well. And that's important, and I'll kind of come back to that one, but they have to communicate well to decide important things regarding the children's lives, where they're going to go to school, who their primary care physician is going to be, where they're going to have their dental appointments. Can I place this child into counseling or therapy? Or do all these things need to be agreed upon by the other parent? That's joint legal custody in a nutshell. Joint legal custody is that one parent or the other, that the parents make these decisions together. Sole legal custody means that one parent gets to make these decisions. So the way that I always tell my clients, if you want to be in a situation where you have joint legal custody and it works well, you have to be able to show the court and the other parent and everyone involved in the case that I can communicate effectively with the other parent to make these decisions. A big part of that is just day-to-day communication via text or email or telephone calls with the other parent. If they're hateful in nature, if they're rude, things like that, that's going to get passed along to the judge. The judge is going to eventually see that one parent or the other is unable to communicate and co-parent effectively, and joint legal custody may not be an option, and the other parent may get sole legal custody.
Yeah, legal custody, I think, as we talk about kind of the very beginning of divorce school, is so important to understand, because not only about what does it mean and positioning yourself to kind of achieve what you want, but you have to be careful, because a lot of things as you make it through, and I know we're kind of jumping all the way to the end of a case, but the language, meet, confer, and agree, is typically what you see in a legal custody language. You don't want meet and confer and consult, because then you have a situation where you may have joint legal custody, but all they have to do is say, what do you think about this, doctor? And you say no, and then, okay, thank you, click, and they make the decision, right?
Sure. And that is the way it happens sometimes. And sometimes depending on what state you're in, it's viewed differently. I know that the two states that I practice in, Kansas and Oklahoma, they view the joint legal custody provisions very differently, or I'm sorry, just the legal custody provisions very differently, meaning one state prefers to have joint legal custody, the other state prefers to have sole legal custody, but it ultimately comes down to the communication of the parents being the number one most important thing. So always be careful and watch out for how you're communicating with the other parent throughout the entire process. You hate for those things to come back and kind of haunt you. So when we kind of deal with physical custody, I oftentimes have clients come into my office and say, I want sole custody of my child. What they're really saying is, I want primary physical custody. Now we're kind of developed or going into the area of, where is this child going to spend most of their nights? Is it going to be with mom? Is it going to be with dad? Or is it going to be with both parents? And so I kind of have to say, no, I think you're talking about, when you're referring to sole custody, you're actually talking about primary physical custody. You want your child to live with you primarily, right? Normally they say yes. And so then we have to start looking at the best interest standards of where the child is or should live primarily. And that's kind of a whole other set or whole other category of things that the court is probably going to be looking at.
Yeah, and there's this, we talk about physical custody and what role will you have, albeit it is different typically for a lot of the parents. They live in separate homes and maybe they're sharing it, and you don't get the full amount of time that you want. But I think you're right. You have to define and break down what the terms that people use loosely. I want sole, or I want joint, or I want equal, or I want week on, and whatever that may be. But I think it's important. And one of the things I think we do for our clients is we kind of lay out that roadmap of, here's what the law says. And I think it's important for guys right now, pull out your local statute in your state. Look at the elements that the court's going to consider, because oftentimes I get asked a lot, well, my son wants to live with me and I want him to testify. In Georgia, there are some statutes that allow children to choose based upon their age, and it is required for the court to abide by those decisions absent something else, but that's unusual. For example, here in Missouri, there are 8 factors, and the choice of the child as to their parent is the last one to consider. So maybe you can talk a little bit about the factors, just summarize them, and then that age question that everyone wants to know is, when can my kid make that decision?
Yeah, that is a question. That's a myth. It's a myth that I heard when I was a child, and it's a myth that I believed all the way up until the time I started practicing. And what it ultimately is I've heard my child can choose where they want to live once they reach the age of blank, 12, 16, whatever it may be, depending on where you are located in the United States and what you've heard growing up. But ultimately, that's a myth. And I always kind of tell my clients, the court has, or the judge has jurisdiction to make these decisions regarding where this child is going to live up until the child reaches the age of majority, which is 18. Prior to that, the child's choice or their desire is taken into account, but judges realize that children can sometimes be easily manipulated. And what I mean by that is, if one parent says, you come live with me and I will buy you a new car and you won't have a curfew, where is the child going to want to live? With that parent. But is that the best for the child? Probably not. And the judges oftentimes understand that. So they'll listen to the children and what their needs and wants are and desires. But I've never seen that a judge puts a ton of weight on that. So the other more important factors that you're going to want to look at are the child's influences in the community. How long have they gone to the school that they're in? What are the parents' working hours? If you have one parent that works day shift Monday through Friday and the other parent works weekends and evenings, then that's going to be a huge factor in determining where the child's going to be primarily. So there's a whole list of factors, and Scott's correct. You need to check with an attorney in your local area, find out what those factors are, and just kind of start going through them one at a time. Which one fits my specific needs in this case?
Yeah. And I think it is important. I always tell my clients, whether it's in a consult or they've retained, that oftentimes we can find other evidence rather than having your child come in. I've done it a couple of times because it was necessary, but it should be the last resort simply because it does anger the judges. I don't care what state you're in, judges don't want to do it. But we could if we needed to. But again, review those factors. That's kind of what's going to guide you. What's going to happen? What's my life look like? But for me, and one of the reasons I think it was important to start off on this topic, and then we'll move on, is to talk about the legal side. That's so critically important. The major health, education, and welfare decisions for children, that's something that guys don't want to miss out on. So if you haven't had that conversation yet about legal custody, what does it mean in your state? How do I get equal rights? That is important. Start there first and foremost. So Brad, thanks for talking about custody in a nutshell, really. That kind of gives us a little high level talk about it. So appreciate it. Yeah, Jessica, let me talk to you. One of the things that oftentimes I get asked right away in a consult or clients just retained is, should I move out of the house and should I be filing first? That's just such a real critical question that they have to make a decision pretty quickly right off the bat, whether they've consulted with an attorney or not.
Absolutely. And I know that sometimes it just depends on the dynamic in the home. So first and foremost, you have to ask yourself, is this toxic? Is it hostile? Is there a chance I'm going to catch a case if I stay? You definitely don't want to be in a home where it's you can't even breathe, or that there's a risk that there's going to be some domestic violence or other issues. The other question that you have to ask yourself is, what's your goal? Do you want to keep the house? Is that something that you've thought about? You definitely want to have a plan before making any moves. So if it is your goal to keep the house, some states have an abandonment issue that could come up. If you move out, could be considered abandoning the asset. And I, as you mentioned earlier, I'm practicing in Arizona. In Arizona, it doesn't change your interest in the home just simply by moving out. So there is no risk that you're going to lose your right to the house. But you do want to ask yourself a couple questions, like financially, can you afford it? Can you afford to cover both the bills in the home if you're ordered to in the divorce, as well as the new place that you're staying at. Maybe you don't have any expenses. Maybe you're moving in with a friend or a relative who's going to help you out. In that case, you might be able to continue paying those expenses. The other thing you might want to ask is there property in the home that you want to protect or that you need access to? Sometimes what happens when one party moves out is they're ousted from the house. And in Arizona, you can't change the locks. You can't really keep a party from the residence if that's where they live and you're married. But it happens. It happens a lot. And so the risk of you moving out and not having access to the home is real. If the divorce has already been filed, a petition is filed, then there's also temporary orders that can order that one party retain exclusive use of the home, and that would prohibit you from entering back into the house during the marriage. So if there's things or property that you need access to, then that's also something you want to ask yourself. And a big question, if there are children involved, is whether or not you have a plan in place regarding visitation. So sometimes when a party moves out of the house, the other party, upset and maybe withholds parenting time, and you don't have a schedule in place. That's a big deal for a lot of people. You have when parties live together, there's a custodial environment that's implied. You see the kids every day. You have a relationship with the kids every day. You help with the pickup drop off, possibly you help with the dinners. Those are all things that if you move out, you may no longer do or have the opportunity to do because of your spouse and the actions that they take. And that's a risk down the road if you are requesting parenting time, custody of the children. If it's been established that you've been outside of the home for a period of time and haven't had access to the children, that could hurt your case if you are going to be requesting some parenting time, et cetera.
Yeah, I think it's really critical, as you mentioned, as you think about it. One of the things, the mistakes, we do a seminar called 10 Stupidest Mistakes Guys Make when facing divorce. And really, this is one of them. And that's why I think it should be a divorce school 101 is an emotional decision. Most of the time, I have a client that comes in, yeah, I moved out. I can't live with them. They're driving me crazy. All she does is yell at me, and they moved out. And then that decision alone, before you even filed, before the action's begun, before you've even consulted with a lawyer, can have such huge consequences, as you were alluding to. Financial, I call it double household expenses. Custody, I always refer to as she's now driving the bus and controls when you can get on and when you have to get off. Because right. I can tell you with kids, if you're going to walk away, you're not abandoning them, but you're losing control and the right. ability to see them. That is, those 2-3 factors are huge. And now again, as you rightly point out, physical domestic violence, that's a game changer completely. But it really emphasizes the point and the importance of scheduling a consultation with a lawyer when that decision may be that you still move out. It may be that
Absolutely.
you stay. And I've had guys, I don't know about you, I've had guys who come to me and, okay, let's get you back in the house. And we've successfully made them move back in because they made a rash decision to get out. Have you had experienced something like that?
Absolutely. Absolutely. And I think, like you said, it's driven by emotions. And so we strongly advise clients that if you can stay, if you can tough it out, if you can work out a schedule where maybe she stays at a friend or relative's a couple nights a week to alleviate, the contact or the arguing in an effort to keep, that custodial environment intact for the kids. That's always advised. And the other question that we get a lot is, should I file first? Does that make a difference? And when it comes to, in Arizona at least, it doesn't make a difference necessarily with regard to rights or access. Each party will have the opportunity to make their requests in the petition or in the response. But there is an issue if you guys have already separated and one party lives in a different county or a different state. It is important that you get that petition filed as soon as possible, and served is the more important part after filing to establish jurisdiction. So if there's a jurisdiction issue, definitely contact one of our local offices where you are to find out how soon filing. Also assets, the house in particular, things in the house, bank accounts, those are all important. When in Arizona, the property is divided as of the date that the petition is served. And so if you're talking about timing, you want to meet with somebody to determine the best time to file and serve based on, the assets and the things that you have together.
Yeah, filing first has been, gosh, I've been talking about this for a long time. And I always mention this in my seminars that we do in person and sometimes virtually. And that is 28 years ago when I first started practice, almost 29. Filing first was critical in that the law allowed that whoever had actual physical custody of the kids at the time of filing was the sole primary physical parent until further order of court. So it was this mad rush. I remember the time when I'd say, okay, do you have custody? I'm standing at the clerk's office. Yes. And then boom, I stamp it in. And filing first took on a whole different meaning back then. Now it's transitioned into a number of different things, and that is strategic. I like to file first in a lot of cases simply because I want to present my evidence first, especially if I have misconduct or if I have bad facts. I want to set the stage. I want to tell the story. I want the judge, remember, judges are derailed by emotion. Their attention span is the same as a jury. I did jury trials as a prosecutor. I did employment defense, and you knew I had maybe an hour, and then they start to wander. And then especially if it's very detailed, you're not going to have their attention. And so that's why I think filing first is always a consideration. There are a whole host of other things, debt, someone's running up the debt. And I know in some states the property is valued as of the time of filing, or that's the marital pot. And I mean, all of these things, and we talk about divorce school, they're so critical. And it really emphasizes just have that conversation with a lawyer. Wouldn't you agree?
Absolutely. It gives you that control as well. Like I said, if you wait till she files, you don't know the date that you're going to be served necessarily. And again, on that date, everything is divided, at least in Arizona. And so with you being the party filing the petition and arranging for the service, you have more control of when those dates are set. And as you mentioned as well, petitioners go first in trial. So you get the opportunity, and sometimes even are given an opportunity to have the last say, the final say in a trial. The court will address you last. So there are some advantages if you know that your case is not going to be settled outside of court. Absolutely.
Yeah, that's great. John, here's the next question I know that comes up quite often. And that is, all right, I filed first or I haven't filed. What do I do about the important parts? Cash, which includes checking accounts, savings account, investment accounts, because I know if I don't do anything or I don't have a conversation about it, she's going to. And I always talk about this is one of the mistakes guys make is doing nothing. But what really should they be doing? And there's some complicating factors depending upon the local courts and the local rules, right?
Exactly. And throughout this process, there are two themes that I'm going to just keep on harping on, and that's accountability and credibility throughout this process. So, and then, as you said, this is all going to be fact specific as to each particular case. But there are several options as to what you can do with the marital funds at the time the divorce is filed. For instance, in Tennessee, we have what we call mandatory injunctions, which prohibit parties from withdrawing any cash or excessively spending. It's what we call dissipation of marital assets. So it prevents a party from going above and beyond the normal everyday expenses to intentionally, waste money or conceal money from the other party. And the last thing you want to do when you're starting a divorce case is give a negative view to the judge, immediately withdrawing all the funds. That also opens you up to potentially paying any child support or alimony immediately, because if all the marital funds are out of the bank account, then the other spouse is going to need your support immediately. So it's something to consider. And, throughout the process, there's also going to be transparency. We have ways to determine what's happened with the marital assets. There's discovery procedures where we can ask questions or request documents from the other side. And if they refuse to do that, we can also subpoena those documents through a court order. So the funds are going to be traced. We're going to be able to see what has actually occurred. And, if you're not trustworthy and honest with the courts, they're going to take note of that. And it's going to hinder your case in other aspects as well.
Yeah, I mean, I think it is. It's so critical. I have a case that's going on right now, and the other side made the critical error of taking steps after the filing, because in Missouri and especially in St. Louis County, there is a kind of a freeze order, an injunction that is entered that says, okay, you can't do anything. You can't change utilities. You can't change health insurance. You can't spend this money. You can't drain accounts. This kind of just, local stop. And I get it, but I think this is all about planning, strategic, doing it before things happen. That's always important. I've always talked about most people, most countries, they have this war room where they do a lot of strategic, planning before they actually go to war. And they think about, what did we do here? And that's kind of the point here, is developing a strategy, or through that consult, laying it out, and then you making the choices. We're going to lay out, okay, here's the good, the bad, and here's what we're likely recommending for you. But I think that's equally important, especially when you're talking about cash, because I can tell you from experience, and the long time I've been doing this, guys that don't consider this, they go to their checking account and it's drained, because I know the other side is going to say, go take it all, because that really leaves us to the point of the options. And
Right.
You can make reference and comment. I'm curious your comment. You can leave it all, take some of it, or take any percentage, whether it's 10%, 50%, 80%, spend it all, in terms of what you're going to do with it, and wisely. And there's other options. Whether we use it for fees, or whether you use it for kids, or there's some other strategic thinking, if you have a business owner. But those are really some of the options, and I'm curious what your thoughts are.
Sure, and I'll address those, individually. So first off, we could leave them as they are. So this is, again, going to be fact specific, but if you leave the funds as they are, it is going to prevent the other party from claiming that you have dissipated the assets. However, if you know that the other party wants to waste the money, then you need to do something to prevent that from happening. So that gets us to the next idea of taking some portion and then placing that in a separate account. So what that is going to do is give you kind of an emergency fund, so that those funds can't be dissipated by the other party. However, it also helps you because there is still some remaining marital funds for the other party to use, so that minimizes that claim for any spousal support or any child support at that time. In addition, you're getting back to this idea of tracing the funds. You need to make sure that you can account for any sort of movement in the bank accounts. We don't want the judge to think that you're intentionally hiding assets. So when I always advise clients that if they move the funds, be prepared to show it to the other side. And I usually tell them to try not to spend it if at all possible, because that's going to come up in the division of marital property later on as we get further into the litigation process. Finally, you have take all in place in a separate account. I never advise that because, again, that exposes a party to potential support issues. It also sets kind of a precedent of negativity to the judge. We want to make sure that we try to get this divorce done as equitable as possible. I always tell clients that 95% of divorces end in settlement, and that's a good way to prevent that from occurring by starting this off by being antagonistic to the other party. Then the last option would be to spend all or some portion and then either move it to a separate account or leave it as it is. I always advise clients do not spend excessively because the other party is going to use that as a claim for dissipation of assets. For instance, if you were to spend money on a vacation or something like that, that is not a tangible thing, the other party is not going to be able to get those funds back. And they're going to have a leg up on you as to say, well, he intentionally did this so that I wouldn't have the funds, and now I need more support. So if anything, the judge can order that tangible property. Let's say a client goes and buys a car. The judge could order that person to sell that property so that the other party can be compensated. So I think it's in your best interest for the most part, and again, this is fact specific, but to take some and place it into a separate account, but just be aware that the need to trace those funds is going to occur in the future.
Yeah, I think so. I mean, I think it's a big decision. I think there's a lot, and the things that we're kind of raising here is, the filing first, do I move out? What do I do with these? These are the three really critical components to talk about with your lawyer right on the front end, and then educate about what about custody? What's my life look like? If I don't have kids, we're talking about property and assets. But let's kind of transition, Jamie, as we round out kind of the divorce school and we get to our questions, and we have a number of them submitted already, but keep in mind, submit those in the Q&A section. If you have a question, we're going to get to those here very, very shortly. Let's talk about the one thing that's sitting out there, whether you have kids or whether you're in a long-term marriage, and that is maintenance, alimony, spousal support, and child support. Will I have to pay it? It is always the question. So maybe let's focus kind of a quick, give us a tutorial on child support, at least in Colorado. It seems to be a little bit more straightforward in some regard, where spousal support and alimony gets a little technical. It varies state to state. At least in Missouri, it varies judge to judge, county to county, and they have the discretion. So maybe you can kind of inform guys on whether or not what's going on with child support and spousal support.
Yeah, absolutely. So I've been practicing for about 13 years, and in Colorado, unlike other states, child support is it's pretty much set on a mathematical formula, and it really comes down to how many overnights does each parent have with the children per year, and what is each party's gross monthly income. The courts really cannot deviate from the legislative formula that has been passed to calculate what the support is. There's a common misconception that if you have 50-50, meaning you and your ex are exercising the exact same amount of parenting time, that there won't be a child support obligation. And that's just not accurate, because it comes down to what is each party earning. Because if one party's earning more, then the formula is going to say that they share a larger percentage of the cost to raise a child. So in Colorado, it's really going to come down to making sure that the income numbers, the gross monthly income that you put into the formula, is accurate, because there's really not much else you can do to get the court to deviate. There's a few minor exceptions with if there's some extreme, extraordinary expenses. Let's say you have a child who has special needs and has a lot of high out-of-pocket medical expenses. We're talking thousands of dollars. In that situation, the court may be able to deviate from the formula. But absent some rare, very expensive circumstances, it's really, like I said, going to come down to what income number are we using. And so when you have a spouse that, historically didn't work during the marriage, you are going to have to make sure that you talk to your attorney about income imputation. What can they earn? What should they earn in the future once the divorce is final? Because absent them being, physically disabled or having some other serious condition, the court is going to expect them to be earning something. So that is really different from spousal maintenance, which in Colorado, it's a much more discretionary formula. The statutory factors that the judge must consider are very, very fact specific. So no two cases are the same. Literally, it's going to come down to a lot of things that occurred during the marriage. So one thing that I always talk to potential clients about in consults is the court is never going to reward someone for not working. That is not the purpose of spousal maintenance. The court looks at what have the parties acquiesced to during the marriage, meaning what type of lifestyle did you guys set up? Through practice over the last 10 years, if you, by mutual agreement, decided to go out and be the breadwinner, and your wife was the stay-at-home parent or only worked part-time, and that's how you guys lived, the court is not going to expect or presume that she can go out and start earning six figures or whatever is close to what you're earning. They look at what did she rely on during the marriage? What did the two of you, decide to do through your, practice over the years? And they're going to have to consider what was the lifestyle during the marriage? How much did your spouse rely on you? How much did she bring in through her job versus your job? the purpose of maintenance is to account for, okay, now that she might be on her own, is she able to meet her reasonable financial needs? But at the same time, the court understands that the paying spouse is also going to be required to meet their own reasonable needs. And so the court has to consider, can that spouse pay maintenance while also meeting their reasonable needs? There is what's called a discretionary or guideline formula in Colorado that the courts can look at to kind of give them a recommendation for what maintenance should be. But they're not required to follow it. It's not mandatory at all. And the factors that the court has to look at before even, looking at the formula and saying this looks appropriate is things like, predominantly who was the breadwinner, what was the lifestyle during the marriage. They also look at whether the husband has contributed to the wife's education or ability to earn. So for example, I've got a lot of clients who said, well, I took care of the kids. I was working full time, but I also took care of them while my wife went back to school. We paid, we didn't take out loans. We paid the tuition through my paycheck, or I, paid for her to get her realtor's license, and she never did anything with it after, but she has that ability, and I helped, make that possible for her. That's a factor the court must look at. They have to look at what have you contributed that, could help her get out and start earning a living, even if she's not actually using it at that time.
Yeah, the maintenance it's really the kind of the one thing that's out there that many guys struggle with, and including lawyers, I think, because in many states it's discretionary. But I know, Brad, I'm just going to ask you real quickly, because I think Kansas is the one that has, is it like maximum of 121 months? Or I just remember something like that in Kansas, right?
Yeah, that's correct, Scott. It is maximum 121 months, but at the same time, there's really not a good formula. Every state has a different formula. Every judge has a different formula that they like to use. Usually it's a certain percentage of the difference in income for a certain period of a length of your marriage, overall marriage. And so there's just that is one of the most difficult questions that us as attorneys have to answer when our clients come to us and say, what am I looking at regarding spousal support? How much is it going to be, and how long am I going to have to pay it? Well, bottom line is does he or she have the need, and does the person that's going to be responsible for paying it, do they have the ability to pay? And if the answer to those questions is no, then that's a good way to potentially avoid having to pay for spousal support. But you're right, Scott, other than Kansas, there's not really a set limitation as far as the time frame.
Yeah. So Jamie, just kind of in the last couple of minutes, there are ways, I think, and when we talk about whether I have to pay alimony or spousal support, there are ways, unique ways to try to avoid it with overpaying in property, big disproportionate distributions, whether it's from retirement or other assets that you can employ, because it's so discretionary. And I would say I could take 10 cases, 10 same facts, 10 different judges, and get a different maintenance result. It's just the way it is. So it is important to consider, as you suggesting, is other ways to try to avoid paying the maintenance, right?
Absolutely. So one of the things that we always discuss with clients is, are there offsets? Are there things that you can offer in order to reduce your maintenance exposure or to get her to agree to waive claim? So a common one is if there's a lot of marital debt. Let's say you guys have a lot of credit card debt or a large personal loan hanging out there. In Colorado, we're an equitable state, but in practice, typically marital debt, same thing with assets, get split 50-50. But you can offer to, say, okay, we have $50,000 in credit card debt. Instead of her being responsible for 25 grand, how about I agree to be responsible for all of it in exchange for her waiving claim to maintenance or for a reduced amount. Or you can decide to do a different split for equity in the house, or if you're going to sell the house. Instead of saying, okay, we're going to split the proceeds 50-50, you could offer, to waive claim to all of it, or to a 70-30 split. The other big issue is making sure that you can present evidence to the court to get her potential income number as high as possible. So sometimes you can use what's called a vocational evaluator, who can go in and do an investigation, do some testing on the requesting spouse and say, okay, based on her past work experience, her education, whatever degrees or licenses she possesses, she could earn X dollar amount, and try to get the court to plug in that number for calculating support instead of minimum wage or whatever she's earning if she's voluntarily underemployed.
Yeah. I mean, I think that, as we get to the question and answer now, now's your chance to submit a question. We have a great number of them in the Q&A section. Do that now. But yeah, to kind of end that segment, it's just so important in everything we've done. I know I say it, it's critical to have that conversation with an attorney, go through some of the options, even though some are formulaic. It's not as straightforward of, oh, it is what it is. We can't do anything about it. So I think it's so critical to understand what your rights are, what the strategic ways to try to minimize the effect of some of these. It's important. So thanks, Jamie. Appreciate it. All right, let's get to the Q&A section now. We have about 20 minutes left. We'll go through some of these and try to get some of the answers for you. Now, keep in mind, obviously, consultation is the best way to do it. We can't give you any legal advice in this. It's just going to try to guide you in the right way and try to give you an overview of the law, but not as it applies to your case. So let's just start out, Brad. Jim in Tennessee. Can or should you deny your wife from attending a weekend camping trip you have planned with the kids? This is before the divorce is final. So imagine they're in the middle of a divorce and he wants to know whether or not you should deny the wife from attending a camping trip with them. Obviously, it's going to be specific. So kind of generalize and go through some of those.
Yeah, generally, I don't think that would be a good idea. And I'll tell you the reason why. It goes back to kind of what I was talking about earlier. How well can you communicate and co-parent effectively with the other parent? That to me is a big red flag. Whenever a client or anyone says that they want to deny the other parent some time with the children, especially doing an activity that the children would probably just love, going camping, going to a lake, whatever else is involved with that, you don't really want to deny the children. So I always tell my clients, kind of look at it as you're not hurting the other, your ex-spouse, you're more hurting the children. And do you want to do that? No. So the bottom line is, I always say, absolutely, let the children go with their mom. Let the mom have some of that time. It's going to make you look good in the end, too. It's going to make, if that's something that an attorney can show the judge that you are willing to continue to develop that relationship between the children and the other parent, it makes you look good.
Yeah. I think it is. Appearance and presentation, I think that's the key is, and I get it. It's sometimes it's not what you want to do, but it's probably the best thing that you should do. And so I agree. So Jamie, here's a quick question. How do you find, or how do you look for hidden savings after your spouse has turned in their discovery page? So what are you looking for? How are you trying to find something that they've kind of accumulated some assets they haven't disclosed? How would you go about doing that?
Yeah, so that really comes down to having a good attorney who can go through and analyze in depth the bank statements, because typically when assets are being hidden or accounts are not being disclosed, there is circumstantial evidence that they exist, whether it's through transfers from a joint account or marital account that they have disclosed, or withdrawals that aren't being, there's no record of showing, okay, where did the withdrawal go? A lot of times it's just going to require some deductive reasoning, having an attorney with a good eye that can go through and say, okay, there's something missing here. Where are these funds going? Or, where are they coming from? If you have knowledge that during the marriage, your wife mentioned maybe 2 years ago that her and her mom were talking about getting an account together, you need to tell your attorney little things like that maybe never came to fruition. You never really found out if it actually happened, but you remember there being that discussion and you suspect that assets are being hidden. Bring that up to your attorney and say, I don't know if this is what happened, but I do remember a few years ago, she, said that they might do this, or that she was thinking of getting another account. Since that was said, can we serve formal discovery? Formal discovery is a way to get the other side under the law. They're required to produce other information. We can also subpoena other records that may not necessarily be in your spouse's name, but perhaps they're in a relative's name, her mother's name. We as attorneys have subpoena power and can go searching for them through that method as well.
Let me stay with you real quickly because it's a follow-up question for someone in Colorado who had a consult and they explained about a no fault in Colorado. What does that really mean, a no fault state in Colorado? 30 seconds.
Sure. So no fault means that the court does not care if either side has been unfaithful. If there was an affair that led to the breakdown in the marriage, if either side had a significant other, it cannot come into play whatsoever. And the court will not make any orders regarding the division of assets or spousal maintenance because someone, is at fault for, not being faithful.
Great. All right, Jessica, question is what happens or what do we need to amend a decree? I imagine they're looking to modify, and maybe you can talk about you can't modify property, but you can modify custody and support.
Sure. Thank you, Scott. So modifications generally, typically in Arizona, occur after a year has passed since the decree. So timing is important. Definitely ask an attorney whether you have any standing. You want to avoid the other party filing a motion to dismiss because you filed it too soon or you don't have any real grounds for the filing, because then you could be on the hook for the other party's attorney's fees, which is a real risk. So make sure you meet with an attorney before you do that. But modifications of parenting time or child support or both, or spousal maintenance, their petitions filed just like the original petition in your case was filed. And again, depending on what you're requesting, there are specific grounds that have to be met before your petition will be heard to modify. So it's important that you meet with somebody so that you can, before you file anything, so it's not kicked out or dismissed, or that you aren't being found to be, just trying to harass the other party regarding those issues.
Great. All right, John, Damien wants to know, wife left the home, took a vehicle, which happens to be the best one. Damien also has a sports car, but wants to know if he's going to be forced to sell it or she can actually take it in the divorce, even though she took the best vehicle herself.
Well, in Tennessee, we are an equitable division state as well. So they're going to look to that property and divide it so that it's a fair division. In terms of figuring out the value of those vehicles, that'll come into play as to whether she gets to keep it and maybe he gets more property in another aspect of the divorce. But if there are minor children involved, and I'm not sure, just based on the question, but let's say dad has a sports car and he no longer has the ability to transport the children, that's going to come into effect as well. So he may want to consider selling that vehicle and getting something that would be able to transport the children if that were the case. But
Yep.
Usually the courts are going to try to make it as equal as possible in the long run.
Agreed. All right, Brad, let's see. The question is, I'm at retirement age. How does this affect alimony? Because my income obviously is going down. She has 9 or 10 years before she's at retirement age.
This kind of goes back to what I was talking about earlier when you're kind of balancing the need versus the ability to pay. Someone's ability to pay is greatly affected when they retire and they're no longer able to work and or earn what they were earning at one point in time. So a lot of states, you have the ability to set spousal support. It can be modified at a later time if there's a change of circumstances, but normally it can only be modified downward. Meaning the court cannot stick somebody with a spousal support obligation whereby they could potentially in the future be set up to not be able to pay it. Take, for instance, if the spousal support obligation is $1,000 a month for 10 years or however many years it is, and that person becomes disabled after 2 or 3 years of paying on that. They're no longer able to pay that obligation, and it needs to be modified to either eliminate it or to a level where they can actually afford it. So this court is going to allow you to modify it downward if needed. And if you're really close to to retirement age, a lot of times judges will take that into consideration, knowing that under whatever retirement plan is, whether that be Social Security, a 401k, or wherever you're going to be drawing your retirement funds from, that they may not be as much as you were earning when you were actually full-time employed. So there is the ability to reduce that in most states.
Yep. All right, Jessica. Question is a family case is currently on appeal, it appears, and it's pending. But during this appeal, some events have happened that potentially warrant a motion to modify. Question is this recommended to file? The case is one parent is unwilling to completely communicate at all. And the question was, can they modify during the pendency of an appeal?
Thanks, Scott. So it really depends on if it's actually an appeal, or if you or your attorney has filed a motion to amend the order. So sometimes that's confusing. If you filed to appeal and it's at the appellate court, then generally anything in the superior court, or in Arizona at least, anything in the lower court would be stayed. So it wouldn't make any difference to file right now until the appellate court ruling has come down. So it's important to find out, is it really an appeal, or are you just filing to modify or amend the decree because of something that was in it that was incorrect or that you didn't agree with? But again, if it's an appeal, our advice would just be to allow that process to be complete before filing your petition to amend.
Great. All right, coming back to you, Jamie. Bruce in Colorado changed locks a year after she moved out because she kept taking things, coming. He'd given her anything she wanted, but she continued to return and not telling him, and pick up their son and not know it. He didn't get a court order to do it, didn't get a restraining order or get sole possession of the house. Is this a problem for him to change the locks when she's moved out?
So it all comes down to timing. If she has been out of the house for over a year, and you've already filed for divorce, it's pending in Colorado, most likely the courts would say that she's kind of already given up her right to physical possession. As to whether or not it's a problem, that's going to come down to whether or not she tries to pursue something with the judge and claim that you did something inappropriate. This is one of those areas in Colorado that it's really just kind of a gray area. There's no bright line rule. The court kind of looks at the totality of the circumstances, how much time has gone by, what precipitated him needing to change the locks. Was that a reasonable, reaction based on her behavior? So this is something that Bruce would need to really, speak to his attorney about because it's so, fact specific. But I would think if it were my client in that scenario, I would say that it's not something probably to worry too much about unless she brings it up to the court and we have to defend it. But there would be some good faith arguments for taking those actions, definitely.
All right, John. Question is what happens if you have a house and the spouse does not want to leave the house? The spouse cannot buy out or afford the house. Can the spouse still be awarded the house?
So the court is going to look to who can actually afford to make the payments. It also is going to be a fact-specific question as to whether the party that is no longer going to be living there is required to pay alimony, because that would be a way that spouse could actually afford that house. However, in Tennessee, with most of our cases, we would usually have one of two things happen with the home. Either one party would refinance and then pay that portion of the equity to the party that is not receiving possession of the marital home, or the parties could agree to sell the home and then split the proceeds. But I don't see, unless there is some sort of spousal support, I don't see a court saying, hey, you get to keep the house even though you can't afford it.
Yeah, agreed. Let's see, Brad. Roger has a question. He's been working at home, has a shop full of equipment that he uses. If he has an auction, presumably to sell that equipment before filing, what impact does that have on dividing assets?
That's someone mentioned this earlier, the whole timing issue. Timing in these types of cases is everything. So a lot of times what I've seen happen at least in Kansas and Oklahoma where I practice, if you sell things or dispose of assets very close in time to when you are actually going to be filing the divorce. A lot of times the judge will throw that in as part of the marital property, even though you got rid of it prior to the divorce being filed. And so you're going to have to, if you're going to do an auction or sell any property right before filing, my recommendation is you hold on to that money, do not spend it, put it into an account where you can account for every penny that you earned from that asset. That way you can show the judge later on, Judge, here you go. Here's a document from my bank showing that I received, $20,000 from this auction. Here it is. It's in this account. I haven't spent any of it. The court is welcome at that point to do whatever the court wants to do. And we have a lot of good attorneys here at Cordell Cordell that can make arguments as to whether or not that should or should not be part of the marital estate. And I think it's just going to come down to timing. So too close in time to filing the divorce, the judge may look at it as being marital property that needs to be divided, and you'll have to account for it.
All right, let's keep on moving. Jessica, my wife left me and the kids, and we have money in a joint account. Can I use those funds for the kids on a vacation? 30 seconds.
Yes, especially if nothing has been filed in court yet. The preliminary injunction in Arizona prohibits any party from moving or selling or transferring unreasonable expenses. But if you have a pre-planned vacation, generally in Arizona, you're not going to be found unreasonable for using community funds for that vacation.
Great. Let's see. Let's go back to Jamie. Florida, on the child support, spousal support, and alimony, what is the situation if my spouse has no income since she married me? And I know it's Florida, but generally you can talk about Colorado.
Sure. So if she has zero income because the arrangement was she didn't work during the marriage, the court's going to impute her, meaning they're going to use an income number for her that she is capable of earning, unless she can prove that she has some sort of disability that prevents her from it. So if she used to work early in the marriage or has a degree in something that could allow her to go back out into the workforce and earn more than minimum wage, that may be a good factor for this person to use as her income imputation number. But the big issue is, remember, the courts are not awarding maintenance to reward someone for not working during the marriage. It's going to be based on what was the agreement, what did the two of you, acquiesce to, and looking at how long she's not had a job. What is she capable of earning once she goes out into the workforce? So. Yep. I would recommend that he definitely talk to his attorney about those factors.
Sounds good. All right, real quickly, John on San Diego, not a question, but we're going to have the office reach out to you directly today to make sure to answer your question and your issue that you're having, which we will take care of. Roger, same question. He wants to know if we would strategize. That's the point of a consultation. Roger want to know if we'll help strategize in their personal situation. All you need to do is reach out. 866-DADS-LAW, or you can call the office nearest you. You can go on the website, cordellcordell.com, schedule a consult. So those two are taken care of. But Roger, you'll have someone reach out to you. I just made sure to text the office. They'll reach out to you this afternoon or this morning where you are. Let's see. Let me go to John. What if you contribute to a 401k? Will the judge make you stop? Let me make sure here. So there's more money to give as alimony.
No, typically when a party has a history of contributing to a 401k, the judge is not going to order that they try to change that pattern of contributing to the 401k. Now, obviously, if someone is doing an extremely aggressive approach and it is making it so that they can't pay any spousal support, the judge may change that. But it would have to be a pretty extreme measure to where there is no other source of funds so that the spousal support would be able to be paid. Again, to go back to Brad's perspective, it's going to be about the ability of one party to pay versus the other's need to receive it. And if the contribution to the 401k is preventing that, then there may be some alternative means sought by the judge.
All right, sounds good. Let's see. Let me go to Jessica. I'm filing for divorce and my partner cheated, and I saw that in texts. I also have proof that I was the primary caregiver during our marriage. taking to daycare, pickups. Will this help with the custody battle?
Two-part question. The Arizona is a no-fault state like many others, so find out if your state uses fault against the other party in the divorce process. The other question is, I'm the primary care provider for the child. Keep doing it, document it, get as many witnesses as possible if you need to. If custody is an issue in your case and she's not allowing the contact that you're requesting, those are all facts that are going to support you and help you when you make the request for reasonable, equal, or more parenting time.
All right. Jamie, the house is currently my name only. Should I sell it? We're both in our early 60s, no children.
So in Colorado, how something is titled is irrelevant. If the house was acquired during the marriage, it's considered a marital asset. And so in this situation, the house could not be sold without the other party's consent if it was acquired during the marriage. If your divorce is already pending, the injunction that is put into force in Colorado would again say that the property cannot be sold until the divorce is finalized unless your spouse agrees and you guys execute something in writing. Again, this is going to come down to the timing and what state this person is in and whether there's an injunction in place.
All right. Brad, let me get you one here. Let me find. What happens when one parent, in this case the dad, not married, suffers a debilitating illness or accident and cannot work? He has zero income. Mom is loaning him support. The attorneys are finding sorts of ways to delay the hearings. The ex is relentless and accuses him of faking. What do they do?
Well, that's a really good and very interesting, complex question. It has a lot of different parts to it, but let me kind of break it down. If the person is injured and cannot work, and they're able to qualify for any type of Social Security income, Social Security disability, SSI or SSD, sometimes SSDI, which is a mix of the two, that needs to be some type of letter or claim needs to be made for disability to the disability court. You need to be able to then take that into court, show the judge and or the opposing counsel that, look, I am unable to work, and here are documentation showing that I'm actually trying to apply for disability. If they want to kind of push it further, they may try to pull medical records through subpoena or some other way to get that information to show whether or not you can or cannot work. But there's a lot of different things that I think you can show them just on the face alone that you're unable to work. And I think applying for disability, if that's the direction you potentially will have to head in, I think applying for that is probably the best move. At least you can show the court that, look, I'm not faking this, I'm applying for this. Whether or not it gets approved and it gets you out of that situation is kind of yet to be determined.
All right, two questions. I know we're over time. Let's do this. Let me go to Jessica. If a man moves out of the house at his wife's request, is he relinquishing the rights of ownership on the house?
No, that's kind of what I spoke about earlier, is that in Arizona, just because you move out doesn't relinquish or determine who has more interest in the house. In Arizona, it's community property. If it is in fact community property purchased during the marriage, acquired during the marriage, it's going to get split 50-50 no matter who lives there. Even if you've been separated for years and haven't been in the house for years, it's still half yours.
Okay. And last question, unfortunately out of time, we'll get to the rest at a podcast. Jamie, Jonathan wants to know if you happen to have donated a large amount of money 1.5 years prior to a divorce being filed, can you be accountable for that money?
So this is all going to come down to intent. What was the purpose of the donation? Is it legitimate? Was it done as an attempt to avoid it being a marital asset for the divorce? The court's going to look at what did the parties typically do during the marriage? Did they make donations or contribute to charities regularly? So long as it was legitimate and there's no factors to suggest that it was intended to avoid it being split. It's in the past. It's 1.5 years earlier, and it's not like this is funds that can be recovered in any way. But again, it's going to come down to the facts.
It is, yeah. And whether, acknowledge consent, we have one right now, a case where there's questions about whether or not the money given away or assets purchased for spouses, other family, kids was agreed to. It really comes down to the facts. That's another reason to have a consult. Let's walk through it and see what your exposure is. So I know we had about 15 or 16 other questions. I apologize, we're out of time. We'll get to those in the podcast. Next podcast we record, we'll just go through all those questions in the 15 minutes that we have. So subscribe to the podcast. It'll get dropped and you'll be able to get answers to your questions. So thank you for joining today in your virtual town hall. Again, we can help strategize, talk about the facts of your case, apply some of the law, and give you some direction. You can give us a call at 866-DADS-LAW. Find us on the web, CordellCordell.com. Continue to register for future virtual town halls. We'll continue to go down this path. If you have any questions, again, reach out to us. Thanks for joining, and until next time, have a great week.